Big week at the Supreme Court of Canada. It's day 2 of 4 for the hearings into Quebec secularism law, Bill 21. Now, lawyers challenging Bill 21 argued yesterday the legislation goes too far and is unconstitutional. We heard yesterday from the English Montreal School Board, the World Sikh Organization, and the Lord Reading Law Association, just some of the groups that argued against the bill yesterday. Today, the Supreme Court is hearing the other side of the coin, those in favor of the bill. Let's now head to the Supreme Court of Canada, where we find Andrew Caddell. He's a columnist for the Hill Times and president of the Task Force on Linguistic Policy. Andrew, welcome back to the show.
Hi, Elias. It's good to be with you.
Why was it important for you to be in Ottawa, to be at the Supreme Court for these hearings?
Well, the task force is an intervener and will be heard tomorrow as part of the significant numbers of interveners that have gone into this case. I think there's about 50 at this point. It's quite significant.
What do you think that says, by the way? This is like a record number of interveners. What do you think it says that the Supreme Court said, for this case, we want to hear from as many people as possible?
Well, it's really, really huge. There was a demonstration yesterday of about 100 people, including mostly of Muslims. The two people that spoke were the woman from Chelsea who had lost her job, Fatima Anvari, and also a volunteer with the Montreal School Board, French School Board, who was dismissed as a volunteer because but they both insisted on wearing their hijabs.
Now, what did you make of that first day of questioning? I'd heard, listen, the Supreme Court's job, they got to ask tough questions here. There were some questions about the nature of Quebec, Quebec's distinct nature. What did you make of what you heard yesterday?
Well, I found it really fascinating. I mean, they went to laws. They went to the Quebec Act of 1774, which allowed Catholics the right to work in the public service. They went to an 1852 law from the Canadas, from Lower and Upper Canada, when they were merged, which referred to the Anglican Church as being the sole official religion, and that was actually there was a law passed to prevent that. So they were talking about the secular society, that this is something that always existed, and it existed in law, and therefore this was something that had already been defined. So I found those historic arguments really interesting. Some of the lawyers that I've spoken to afterwards said that they weren't really of any great value. I also found Frederick Verrar, who's going to be on Aaron's show this afternoon, apparently, argued that by having the notwithstanding clause, you really don't have a constitution that can protect rights. And as one lawyer said, Quebec may be unique, yes, but there is only one constitution.
But isn't that interesting, right? Because I saw that exchange, and I think one of the responses from the judges is saying, are you saying we need to rule for a constitutional amendment? Because it's in the Constitution, right?
Yes.
Okay, so based on yesterday and this morning, how do you think this case is going?
Well, today the Quebec government really went after every single part of the EMSB's argument. Mm-hmm. And essentially the federal governments as well. They started out with a lot of technical language about the role of judges and the role of the courts as related to the Constitution, but then they really got into the nitty-gritty and they went after the EMSB's argument, saying that, in fact, although the lower court judge Blanchard said that there was a specific culture to the Anglophone community, they're saying, no, there's no specific culture. There's an error here on the part of the judge, because the only thing that connects the Anglophone community in the case of the EMSB is language and the language of instruction, and that's it. So, and they also went after Section 28, which is the section that protects women's rights, saying that, in fact, it's not really all that significant and should not be applied in this case.
What do you think is, we're with Andrew Caddell, he's a columnist for the Hill Times, president of the Task Force on Linguistic Policy, one of the interveners in this big Supreme Court case that's being heard this week on Bill 21. What do you think your side's best arguments are? It's one thing I'll be asking Guillaume Rousseau from the Mouvement laïque québécois. He's coming up next. What do you think your best cards are to play here? What are your best arguments?
Well, first of all, it's quite obvious that judges are really, really reticent to go anywhere near the notwithstanding clause. They really are trying to avoid it, and I think some of the lawyers as well, that's why they're citing historical precedent that has nothing to do specifically with the Charter. Now, our argument is that, yes, the Charter codified rights in 1982, but it didn't create them and didn't define them. They already existed, and they'd already existed all the way since Magna Carta. And so what we're saying is, let's put the charter aside, let's put the notwithstanding clause aside, and look at things from the perspective of what, as Cliff Lincoln said, rights are rights are rights, of what rights exist for all Canadians. And it's a unique argument. I'm hoping that the judges will listen to it.
Let me ask you if you feel if the Supreme Court has been fair so far. Looking at the interveners that have been accepted, looking at some of the decisions, one judge recusing himself from the case, and they had to whittle down to 7, right, for this
That's
because
correct,
of that
yeah.
recusal. What do you make of those decisions? Do you think the Supreme Court handling this fairly?
Well, I think the fact that they've pretty well let everybody who's applied be an intervener, I think that shows a lot of openness and very much a freedom to express oneself. And in terms of the days, this is really unprecedented. Most cases are maybe a half a day. This is 4 full days, and they're going to take a long time to come to the decision, I think.
And Andrew, of course, I think a lot of your interest in this case, not only has to do with Bill 21, but how a ruling here could have effects on the Bill 96 case, right? So why don't we get into that? Why is this ruling so important for you?
That's why we're here, because the notwithstanding clause would have a significant effect on our case, or our argument could have an effect on our Bill 96 case, in the sense that if the notwithstanding clause doesn't apply, then you can deal with Bill 96 in an open way, and we can really raise the issues of each point of the law that we find very, very difficult or unconstitutional.
Andrew, what do you make of the provinces' stance that are taking the side of Quebec? And these are some provinces that are on the record not fans of Bill 21 per se, but they're like, hey, the provinces have this right. What do you make of that support that Quebec has seen from some of the fellow provinces here?
Well, everyone always goes back to 1982, 1981, when the deal was made to have a notwithstanding clause, that it was done on the basis of support from Saskatchewan and Alberta and Manitoba, Newfoundland, and that this was what the provinces wanted, because they wanted to ensure that their legislatures were supreme. Now, we've never had the notwithstanding clause used in Parliament, but we've had it used now significantly in several instances in other provinces aside from Quebec. So that's why they want to protect their rights.
Andrew, anything surprise you so far?
I found it interesting and a bit surprising how aggressive the judges are in their questioning. Malcolm Rowe, in particular, from Newfoundland, and I congratulated the lawyers yesterday on the fact that they were able to handle it. I also found it interesting that you've got almost every single one of the lawyers who are pleading is female, and it's given this case does affect women. I thought that was quite pertinent.
It's very interesting, and I've heard this as well from other people, that, once you get before the Supreme Court, the kid gloves are off. Like the justices are, and it does, on both sides, they are just like grilling at certain points when it comes to cases like this. Andrew, your insight, greatly appreciated, and thank you for hopping on today.
Okay, have a great day.
That's Andrew Caddell. He's president of the Task Force on Linguistic Policy and a columnist for the Hill Times. Now, when we return on the Elias Macko Show, we'll hear from the other side, those who are in favor of Bill 21 and arguing at the Supreme Court today. Guillaume Rousseau from the Mouvement Laïque Québécois joins us next.
iHeartRadio is throwing it back
2010s, the decade,
to the days of huge hits and unforgettable anthems. A non-stop stream of the biggest and best.
Drake, Rihanna, Beyonce, Katy, Gaga, The Weeknd,
And more. All your decade-defining favorites, all in one place.
Hi, it's Katy Perry.
Hey, it's Bruno Mars.
This is Kesha.
Find 2010's The Decade on the free iHeartRadio app. Preset the station so it's always one tap away.
All right, let's continue our discussion on Bill 21 and, of course, the hearings at the Supreme Court of Canada. Day 2 of 4 of the hearings on Quebec secularism law. And today, the court will hear arguments of those who support Bill 21 and the use of the notwithstanding clause. So far, every level of the courts has sided with the government and pro-secularism groups. The lawyers challenging Bill 21 argued yesterday the legislation goes too far and it's unconstitutional. We head over now to Guillaume Rousseau, who's an attorney for the Mouvement Laïque Québécois and a law professor at Université de Sherbrooke, and he's there at the Supreme Court. Monsieur Rousseau, Guillaume, welcome back to the show.
Thanks.
All right, so Guillaume, let me ask you. It seems yesterday that there were a lot of questions from the Supreme Court justices about Quebec, its distinct nature. Do you think a ruling here needs to take into account the secular nature of Quebec?
Yes and no. Of course, it needs to take into account the intent of the legislature, the will of the National Assembly to make sure that Quebec is a secular state. That's at the heart of the issue here. But on the other hand, in 2015, at the Supreme Court here, the Mouvement Laïque Québécois, we won a unanimous ruling by the Supreme Court saying that the mayor of Saguenay couldn't pray at the city hall during the municipal council, and more broadly, what the Supreme Court said was that a representative of the state cannot practice his religion while on duty. And it's that exact duty of religious neutrality that is now enshrined in Bill 21 and is applied to teachers and judges and so on when it comes to wearing religious signs. So legally we are on a very strong ground, and the only difference with Quebec is that Quebec has a bill. Because of our civil law tradition, we like to take rules and put it in an act of parliament. So that's why we have a secularism act where other provinces don't have it, but the ruling of the Supreme Court in Mouvement Laïque Québécois v. Saguenay applies to all Canada. So basically we have two arguments there. One is that the law that applies from coast to coast does make Bill 21 constitutionally valid, and then also the fact that Quebec has a strong will and has a distinct history that have led it to develop a particular attachment to state secularism. That's another argument.
What other precedents are going to be cited here? Because you mentioned a pretty strong case and a precedent that was set just over 10 years ago. Anything else that you're going to be looking at or presenting this week?
Yes, the other issue is the one about the notwithstanding clause. And this time the precedent is Ford, the Ford case. So basically in Ford, the Supreme Court of Canada said that it was possible for Quebec and any other provinces and even the federal parliament to use the notwithstanding clause without any review from the judicial branch. Or a review that is only about the form to make sure that it's clear that the legislature is using the notwithstanding clause, but it's not about is it a good reason to use it? Is it reasonable? No, that's completely out of the question. The notwithstanding clause is there to make sure that elected official gets to decide, and the ruling of the Supreme Court in Ford is pretty clear about that, and that's why all those who oppose Bill 21, they want to reverse Ford, and that's a pretty heavy duty that they have in front of them because of stare decisis. So you need a really good reason to convince the Supreme Court to change the settled law. So that's what they're trying to do, and we are defending the state of law as it is now with the ruling in Ford.
Having said that, do you have any worries that the Supreme Court could go against the precedent? You know, there are cases where they've done that. I think it was on the right to strike in this country. One ruling in the 1980s, yep, and then a more recent ruling that went completely in the other direction. So do you worry that maybe the Supreme Court will not take that precedent into account?
No, because when you look at in the case law, the reasons why you can set aside a precedent, they are very specific reasons, and clearly they don't apply in the case of the use of the notwithstanding clause in Bill 21. So I'm pretty sure that the court will respect Ford. Then they sort of have a plan B that is saying, okay, we respect Ford, the National Assembly can use the notwithstanding clause to protect Bill 21, but from now on, the court will be able to have declaratory judgment. So basically saying, for example, according to them, that Bill 21 does infringe on freedom of religion, but the law still applies because of the notwithstanding clause. So that's why they're looking for, and Justice Cassira yesterday with his questions seems to be studying this possibility, but I think it's wrong because it would really politicize the Supreme Court, the justice system in Canada, because that will mean that there will be a ruling about a political issue, and then the goal would be that this ruling be a part of the next electoral campaign. So can you imagine the next campaign in October in Quebec? People arguing, politicians arguing about the ruling of the Supreme Court that will make our system more Americanized. It would be like in the U.S., there will be some court bashing and so on. We don't want that in Canada. So I'm going to argue strongly against that in a few minutes from now at the Supreme Court.
We are with Guillaume Rousseau from the Mouvement Laïque Québécois. He's at the Supreme Court this morning arguing for Bill 21 here. Sometimes you can tell a lot about that first day. You touched on it briefly there. What else do you take away from day one from yesterday about how the rest of the week is going to go?
Well, there were some tough questions. So that on one end, it could mean that the case of those who oppose Bill 21 is not as strong as they first thought. But on the other hand, it possibly also means that the judges are going to have tough questions for everybody, including us, including me this morning. So we're going to see after today what's going on with that.
Can I just ask you, do you get nervous when you're going to present in front of the Supreme Court of Canada? Do you get nerves?
It's my first time at the Supreme Court, so of course I'm a little nervous, but we've been preparing for weeks and weeks now, and I'm working with Maître Luc Allary, who's been a member of the bar for more than 50 years, so I'm the junior with him, and he's coaching me, and just by looking at him, I'm getting better, so I'm very confident, but yes, of course it's a little stressful.
Yeah, I can imagine. Let me ask you this. Looking at how the Supreme Court has handled this so far, the choice of interveners, there was a justice that recused himself. Do you think the Supreme Court so far, they've been fair?
Yeah, the question yesterday were very fair, tough question, but legitimate question. So it's been really unifying until now.
Let me ask you to wrap up here. What do you think is Quebec's best case? What do you think is the best arguments that you and the others will put up this week?
I think that there are two very good arguments for Bill 21. One, it's the notwithstanding clause and the ruling in Ford basically saying that the National Assembly can use the notwithstanding clause in a certain way that was explained in Ford, and Bill 21 does respect that procedure to use the notwithstanding clause. And then the second argument, it's really about Mouvement Laïque Québécois v. Saguenay. There's a duty of religious neutrality for those who represent the state while they're on duty. And what the Bill 21 is doing is only to codify that in line with our civil law tradition. So that's it. And there are even some grandfather clause to make sure that it's really a law that can be implemented with a social peace and so on. So I really think that these are our two best arguments.
And let me just ask you, and for our listeners' sake, Mouvement Laïque Québécois, who are you representing?
Mostly parents, and many of them are Muslim parents, and they really want to send their children to public school, but to a secular public school where their children won't be under religious pressure by teacher wearing a religious sign or other member of the other employees. So that's really our focus here is the rights of the parents and the rights of the children. And we're about the only one to really argue for the parents. So that's why it's important that we're here today.
Monsieur Rousseau, Guillaume, good luck today in court. Thank you for joining us.
Thank you.
Guillaume Rousseau is an attorney for the Mouvement Laïque Québécois and a law professor at Université de Sherbrooke.
The newest tracks. Let's go. New music. And the next big thing.
Always on the new music first.
Your first place to hear it all.
'Cause you gon' like it, love it, wanna play it twice. Playing now.
iHeart New Music. Your digital station for brand new drops, fresh finds, and tomorrow's bangers.
I think we need something new.
Discover iHeart New Music. Always fresh, always first. Stream now on the free iHeartRadio app.